Right away, listen to the tension here. This isn't just about a legal violation anymore. This is about identity. Parenting, blame, and accountability are all about to collide in one courtroom moment. Keep that in mind.
I'm not a bad mom, so that's really hurtful that you feel that way. I'm sorry that you feel that way.
Well, okay. All right, great. Okay. I'm sorry that you don't conduct yourself like a responsible parent for the benefit of your daughter. Okay, I'm sorry about that. Okay? That's got nothing to do with anything. Go ahead, Ms. Thomas.
Thank you, Your Honor. So we would just like to ask the court for one more opportunity to give Ms. Rude the chance to see how mental health court can help her, what sort of things she can get from mental health court to help with her thinking. I know she wants to get back on her feet. So we'd just like to ask the court for one more opportunity.
She's going to get another opportunity, okay? Whether that be the history indicates she's not going to take advantage of it because she just doesn't. For 17 and a half years, she hasn't. That indicates to me that she really doesn't have any interest in this. Her interest is in getting off with the least amount of penalty possible. And then she can go back and have contact with Joyner. And you have no concept. You have no concept of why you do what you do. Because you indicated to me that there was a perfectly reasonable explanation for each thing you did. You have no insight into what you're doing, why you're doing it, and how to stop doing it. Now, I'm going to keep you on community control for the same term. You're going to serve 95 days in the jail with credit for 35. After that, you're going to go to NeoCap. You're going to complete that program and follow those recommendations. And you're going to continue in the Mentor Municipal Court Mental Health Treatment Program. And you're going to comply with all those conditions, as well as all the other conditions that I imposed upon you for your probation on May 7th, including no contact with Willis Joyner or any other member of his family.
Can my daughter and I also have a no contact order?
Can your daughter and you also have?
Yeah, because this communication doesn't just go one way. Okay, I didn't reach out to Joyner. He reached out to me.
Okay.
So this is ridiculous that I'm being placed with all these different regulations, and I'm also not just a suspect.
I understand in light of your history how absolutely ridiculous this is.
I can lose custody of my daughter with all these regulations.
Because once again, you bear no responsibility in any of this.
You don't even know me as a person. You're going by a fucking piece of paper.
Right.
That's bullshit.
Right.
I can lose custody of my fucking daughter.
Anything else, Ms. Tomazik?
Nothing further, Your Honor. Thank you.
All right.
You asshole. You bitch. Yeah. I don't need no cap, but yes, I'm pleading guilty to them.
I'll accept your guilty plea and find you guilty, Ms. Tomazik.
Yes, thank you, Your Honor. We would like to ask the court today for any leniency in sentencing for Ms. Rude. Your Honor, I know you're fully aware of her issues with her mental health. Ms. Rude indicates there's a specific type of therapy that she knows she needs, that she does want to try. So, Your Honor, we'd just like to ask the court for any leniency. I did speak with her and her sister today. Currently, both of her parents are in the hospital. They are both caring for her daughter now, and I know Ms. Rude wants to be able to get home, get to her daughter. She's concerned about her parents due to their age and medical conditions, taking care of her daughter. She's trying to make it her priority. She does want to get back to work. So we'd just like to ask the court for any leniency today. Thank you.
Ms. Rude, anything you want to tell me before I sentence you?
I do apologize about how I presented myself a couple months ago. You and my probation officer have nothing to do with the traumatic experience that I've experienced within life. I wanted to be cooperative, but I did go into NeoCap with an open mind. I had a mental break in there. I'm not able to take medication. The meds that I am prescribed, they don't allow them. And I did try my hardest to go to treatment in there. It just was very difficult for me. So I know that you said a couple months ago that you didn't think my daughter was my main priority, but she is my main priority. And I do want to get back home to my daughter. I do speak to her every day. And I am really worried that my parents are something might happen to them. They're both in their 80s. My mom has Alzheimer's, and my dad, he's been like battling on and off with bronchitis for the last couple of months. And today, my dad revealed to me that they were on their way after dropping my daughter off to school, that they were on the way to the ER. So I'm not sure exactly what's going on with my parents, but I'm a little scared. I don't want my daughter to be anything like me. I don't want her to experience anything that I experienced within foster care. And I know that that's the next step for her if my parents, something happens to them. If offered another opportunity into society, you will never see me within your courtroom. And that is 100% on my life, a promise. I won't be here anymore. I'll try my best to just be a better person. And I will absolutely stay away from this past relationship because it's got me into a lot of this, like, serious, serious problems. Like, I now have an open case with Child Protective Services due to what happened that night. Like, so many things going on with law right now. Like, I have another case that I'm fighting in Cuyahoga County. I have warrants that I've never usually would have because I haven't made it to court. I have health conditions and things that I have to get back to my doctors pertaining to. I have a daughter to take care of. I'm not trying to be disobedient when it comes to law anymore. I don't even really want to be in relationships anymore. I just want to focus on me, trying to get myself together so I could take care of myself and my daughter. I'm so sorry for how I presented myself the last couple of months. I'm so sorry for how I dealt with everything pertaining to my mind and my spirit. I will try my best, if given one more opportunity, to abide by my treatment.
Well, the point of back in May, and then once again we were here on the violation, was to put you in a position so you could do everything that you just said you want to do, but you resisted at every front. You resisted at NeoCap, you resisted at mental health court, have been causing problems over here at the jail, and you have, and I don't consider what you said to me in court, I don't really care about. I don't even remember most of it, okay? I don't care. People say stuff to me and call me names all the time. It doesn't bother me at all. So if you're worried about me holding that against you, then that's not a worry. It's not a concern. It's not an issue. The issue is that you've got a violent past as exhibited through domestic violences and assaults that have continued on and on and on. This case arose out of Willis Joyner that you insisted on continuing. It resulted in you being here. Once you were here, we tried to give you an opportunity and an avenue to straighten all this out, and you have just steadfastly refused at every turn. And so this is what you have brought upon yourself. And this hasn't stopped. It's continued since you got back over at the jail. When you are out from under this case, then you can go and get all the help you need and try to change your behavior, or you can just keep doing what you're doing. But there's a predictable end if you keep doing what you're doing. So you decide what you want to do. But the fact is, you're not amenable to community control anymore because there's nothing left to do with you. Even if I wanted to do something more with you on community control, there's nowhere for you to go because nobody will take you because of what the history you have created. You have done that.
I wanted to, I just want to say, when it comes to mental health court, I was actually grateful that you gave me the mental health court. I wanted to still continue to come to mental health court. So I was really confused as to, like, why Judge Trebitz did not want me to be in his courtroom anymore.
Any input on that?
Your Honor, communicating with the mental health staff in the jail, Ashley was approached about mental health court and said, fuck mental health court. That got back to the judge, and the judge terminated you for being back in jail and made you back.
Okay.
I don't recall saying that.
Ashley was being brought from NeoCap to participate in mental health court. When she got kicked out of NeoCap, she was no longer able to do that. I think the attempts to have her continue with that program ending at that time.
All right. All right, well, I'm terminating your community control. I'm going to sentence you to 14 months in prison with credit for 288 days, and the costs are assessed. When you get out, you might be on post-release control for up to 2 years. Under the parole authority, if they place you on post-release control, they'll put conditions on you. If you violate the conditions, they could return you to prison for up to 7 months. If your violation's a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is a greater of 12 months or the time left under post-release control. Anything else, Ms. Tomaszek?
No, Your Honor, thank you.
Okay, I have a question. What about this?
So that's Cleveland.
Right, so
We can't do anything about it. So typically what happens is we'll have to find out if Cleveland has a...
To sit and reflect on my mistakes. At first I didn't understand, but God has granted me the new vision to see my life through a different lens. Because God placed you into my life, I didn't go septic and die in jail. Thanks to the jail and sheriffs for transporting me each week, I have my health back. Thank you so much for this, Your Honor. I've been selfish for many years, allowing my addiction to completely take over my soul, and I realize now that my actions were so selfish. I genuinely would like to apologize to my family and friends, and mostly my mom, because she's all I have. After my dad passed, I have not only let myself down, but my children. I think today was the first selfless act I've done. I asked them not to come because I didn't want them to watch their mother or cause any of them any more pain. I feel deeply it just wouldn't be right. My heart would completely break for them to have to watch me go to prison as well. I will absolutely do every ounce of time God sees fit for me to do. Your Honor, I come to you today with an open heart. I trust that you will grant me understanding with hopes that you see fit, that one more opportunity is granted so I can fix this and show not only myself, but my family and you that I am bigger than an addiction, and please give me one more chance. Thank you so much.
Thank you. Mr. Shapiro for the State of Ohio.
Thank you, Your Honor. First, I'd like to, pursuant to the agreement between the parties, that the court order that the defendant pay $100 restitution to Mr. Robert Taylor, Taylor.
A minimum prison term might sound like mercy, but it still means prison. Defense lawyers often ask for this when they know probation isn't realistic, especially in violent injury cases like this.
This is an agreement that between the State of Ohio and the defendant. This is a car that the defendant struck that night, caused some damage. This is Mr. Taylor's deductible. The state dismissed count 16. It's a misdemeanor in the first degree with the understanding that that would be ordered. So we would ask that the court please do that. Defendant has a drug problem that she has never dealt with, and that exacerbated the offenses here. Maybe it's the root of it. I don't know. Looking back at her criminal history, she has a domestic violence from 2001, and so she does have something other than drugs in her past. I mean, she has a misdemeanor drug offense as well, but some theft charges. These are convictions that are common to people who are convicted to drugs, who steal. But the defendant's 39 years old, hasn't gotten any help for it, and it culminated in her robbing her mother. She was a 71-year-old elderly lady. Whether she was drinking that night or not, she didn't deserve to be robbed and pushed down and get broken ribs. The injury in this case is serious, and I think that differentiates this case. Criminal history, well, there's no felonies, there's a pattern. The state believes that a overall conglomerate sentence of 5 years is an appropriate number of years for the court to impose on the defendant for all of this conduct combined, Your Honor. The defendant does have credit for 93 days. The state would ask for, pursuant to the agreement of the parties, forfeiture of all of the contraband drugs that were taken in the packaging. as with by agreement.
So that is just drugs and paraphernalia we're talking about.
Yeah, there was some items that.
No other property, no phones or money or anything like that.
There was some other stuff that was recovered. Yeah.
I received a victim impact statement. I've considered what's been said here in court today by Ms. Smith, the defendant, statement that she read, the prosecutor, the recommendations from the parties. All of this is considered by this court in light of the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. For the factors in 29-29-12, in regards to count 1, I am going to note that the defendant's son was in the vehicle with her when these drugs were found and the pipes were found. That makes it more serious. And the son's an adult. I don't want to mislead it. It's a minor, but nonetheless, it's a 20-year-old son in the car with her. No other factors are present regarding the offense being more or less serious in regards to count 1. In regards to count 9, the court finds that the defendant's relationship with the victim facilitated the offense. This was her own mother. That the victim suffered serious physical harm, and that injury she sustained was exacerbated due to the age of the victim being 71 years old at the time. As for recidivism factors, the court finds the defendant was on probation at the time she committed the offense. There's a history of criminal convictions, albeit no prior felonies, but a lengthy history of criminal convictions. She's been on probation before in the past. She's violated her probation on multiple occasions in the past, so she has failed to comply with previously imposed sanctions ordered by courts. And every factor is present indicating recidivism is more likely. There's a drug abuse problem that relates to.
This is one of those rare sentencing statements where the defendant lays everything out: addiction, family pain, fear, and faith. But the real question is, does the judge believe the remorse, or is it too late? And here